Balancing informality and structure. Social Security's administrative review process might be labeled informal, but don't mistake that for a lack of rules. It is essential to understand the critical deadlines for evidence submission, appeals, and the limitations when considering new evidence. Failing to meet these deadlines can result in losing your rights to further review, even if you're in court. Hearings before administrative law judges, also known as ALJs, are where this blend of informality and structure is probably most noticeable. These hearings often take place in a smaller conference room or through video conferencing nowadays, rather than the imposing courtrooms that you see on TV. Depending on the individual ALJ, judicial trappings, like we call them, like robes, gavels, bailiffs, and court reporters, usually aren't there. Sometimes there may be court reporters, and I suppose sometimes they may have a robe on, but generally, no, they don't have those. Crucially, the strict rules of evidence that bind traditional courtrooms don't apply here, and this is very important because it would make it almost impossible for a pro se to really present their case. ALJs can consider almost any evidence they deem relevant to the case, even if it's not relevant, even if it wouldn't be allowed in a regular court. However, there is still a deadline. Evidence must be submitted at least 5 business days before the hearing. This flexibility of not requiring the rules of evidence allows for unsworn doctor's letters to carry same or potentially the same weight as a certified medical record, which would be required for admission in regular court. Now, the SSA doesn't mandate specific forms for most submissions. Attorneys usually communicate through letters, whether they're presenting briefs, adding evidence, making requests, notifying SSA of changes. And while a simple letter is technically enough to appeal a decision, using official forms like the request for hearing or request for review of a hearing decision removes or reduces any chance of SSA staff misinterpreting your intent. Unfortunately, while the wait times at every stage of the process can try anyone's patience, claimants with good representation often find ALJ hearings less intimidating than a traditional court hearing. The value of the opportunity to explain their situation directly to the person who will decide their case in the absence of any adversarial government attorney or otherwise opposing attorney makes the process feel less hostile. Navigating this complex and changing system can still be daunting. If you have any questions about this issue or any other disability matter, we're happy to help. Give us a call or reach out at cliffcarlsonlaw.com.